Let's learn together. Sales of Goods Act 1957. What is goods? Section 2. Every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass, and things attached to a farming part of the land, which are agreed to be severed before sale or under the contract of sale. The question is, Maharani Spices, SDNBHD, ordered 2,000 jars of royal masala from Flavor Express Limited. The purchase was made based on both a detailed description in a product brochure and a physical sample provided. The brochure described the product as 100% organic preservative-free, finely ground spice blend, suitable for export to EU markets. The sample given matched this description. Upon arrival, Maharani Spices discovered that the spices were coarser, had a strong chemical preservative odor, and did not meet EU export packaging standards. Flavor Express argued that product variations are normal and that Maharani accepted the goods after a few days without immediate complaint. Advise Maharani Spices whether they can reject the goods or claim damages under the Sale of Goods Act 1957. Let's advise Maharani Spices whether they can reject the goods or claim damages under the Sale of Goods Act 1957. Let's using Iraq method. The issue, whether Maharani Spices can reject the goods or claim damages under the Sale of Goods Act 1957 after receiving products that did not match the brochure and sample. Rules. The Sale of Goods Act 1957 governs contracts involving the sale of goods in Malaysia. It outlines the rights and obligations of both buyers and sellers and includes implied terms that arise automatically in a contract of sale. These implied conditions exist to protect the buyer, particularly when goods are purchased based on a description, sample, or for a particular purpose. Section 15. Implied condition that the goods must correspond with the description. Section 15 of the Sale of Goods Act provides that in a contract for the sale of goods by description, there is an implied condition that the goods must correspond with the description given. If the sale is made by both sample and description, it is not enough for the goods to match the sample alone, and they must also match the description. In LAW299 vs. Cooperative Ceramic, D. Imola, the court held that the buyer could reject the goods if the bulk supplied was inferior to the sample shown, especially when the buyer relied on the quality presented at the time of ordering. Section 15. Implied condition that the goods must correspond with the description. Section 15 applies in two situations. First, when the buyer has not seen the goods and relies completely on the seller's verbal or written description, such as ordering a computer over the phone based on its specifications. And second, when the buyer has seen the goods, but a defect is hidden, and the buyer has relied on the seller's description. This is illustrated in Nagodas Purushottamdas and Company versus Mitsui Bussan Kaisha Limited, where the flour delivered was of the same quality but did not include the agreed branded trademark. The court found this to be a breach of description, giving the buyer the right to reject the goods.
Section 17. Implied condition in a sale by sample. Section 17 of the Sale of Goods Act 1957 talks about sale by sample. This happens when the contract clearly says, or it is understood that, the sale is based on a sample shown to the buyer. In this type of sale, the law gives three main protections to the buyer. 1. Section 17(2)(a). The goods delivered bulk must be the same in quality as the sample. 2. Section 17(2)(b). The buyer must be given a fair chance to compare the bulk with the sample. 3. Section 17(2)(c). The goods must not have any hidden defects that make them not good for sale, and which the buyer could not find when checking the sample. Section 17. Implied condition in a sale by sample. These rules protect the buyer, not just from what can be seen, but also from hidden problems in the goods. If all the goods are bad, the buyer can reject everything. If only some are bad and the contract does not allow part acceptance, the buyer must choose to accept all and ask for damages, or reject all and sue. The buyer cannot accept some and reject the rest unless the contract says it's allowed. In a case Godley versus Perry 1960, a boy got hurt using a catapult that was bought by sample. The shop had tested the sample, but the problem was hidden. The court said that the shop could claim damages because the defect could not be seen during normal checking. In Drummond versus Van Ingen 1887, the cloth looked the same as the sample but had a hidden problem. The court said that the seller broke the condition.
Section 16(1). Implied condition as fitness for particular purpose. As a general rule, Section 16(1) follows the idea of caveat emptor, which means let the buyer beware. This means the buyer is responsible for checking the quality or suitability of the goods. If something goes wrong, it's usually the buyer's risk. However, Section 16(1)(a) creates an exception to this rule. An implied condition that goods must be reasonably fit for a particular purpose arises where 1. The buyer makes known that purpose, 2. Relies on the seller's skill or judgment, 3. The goods are of a description the seller usually supplies. And 4. The goods are not bought under a trade name alone. In the case Baldry v. Marshall, the buyer told the seller he needed a car for a specific purpose and trusted the seller's advice. But the car was not suitable, so the court said the buyer had the right to reject it. Section 12(3). Warranty. Under Section 12(3) of the Sale of Goods Act 1957, a warranty is a stipulation that is collateral to the main purpose of the contract. If the seller breaches a warranty, the buyer cannot reject the goods, but is entitled to claim damages. However, there are certain situations where a breach of a condition is treated as a breach of warranty, as provided under Section 13(1) and 13(2), namely, 1. If the buyer chooses to continue with the contract despite the breach, Section 13(1). 2. If the contract is indivisible and the buyer has accepted the goods or part of them, Section 13(2)(a). 3. If the goods are specific goods and the ownership has passed to the buyer, Section 13(2)(b). Section 12(3). Warranty. To determine whether the buyer has accepted the goods, Section 42 provides that acceptance occurs when a. The buyer tells the seller that the goods are accepted, or b. The buyer does any act inconsistent with the seller's ownership, or c. After a reasonable time, the buyer keeps the goods without notifying the seller of rejection. In these situations, the buyer cannot terminate the contract, but may still claim compensation for the losses suffered. Application. Maharani Spices purchased 2,000 jars of Royal Masala based on a product description and a physical sample. The brochure described the goods as 100% organic, preservative-free, finely ground spice blend, suitable for export to EU markets. The sample also matched this description. However, when the goods were delivered, they were coarser, had a chemical preservative smell, and did not comply with EU packaging standards. This clearly shows that the goods did not correspond with the description, thus breaching Section 15. The difference in texture and smell also means the goods did not match the sample, violating Section 17. Additionally, Maharani made it clear that the goods were intended for export to EU markets. The seller was aware of this purpose. Since the goods did not meet EU requirements, they were not fit for that particular purpose, resulting in a breach of Section 16(1)(a). Although Maharani did not raise an immediate complaint, Flavor Express claimed that Maharani had accepted the goods. Under Section 13(2) of the Sale of Goods Act 1957, if the buyer has accepted the goods, any breach of condition is treated as a breach of warranty. According to Section 42, a buyer is deemed to have accepted the goods if they are kept without objection within a reasonable time. Since Maharani kept the goods for several days without rejecting them or lodging a prompt complaint, this may be seen as acceptance. Therefore, Maharani can no longer reject the goods but is entitled to claim damages for breach of contract. Conclusion. Therefore, Maharani Spices is no longer allowed to reject the goods because they kept them without making a prompt complaint. However, since the goods did not match the description, sample, and intended use, Maharani still has the right to claim damages for the losses suffered. Hope you guys understand. Bye!